Here's a comment that was posted a while ago, which I have just seen. The question is, can you give us some tips on claiming a private loan which wasn't repaid? As a disclaimer, this is not legal advice. It's purely my opinion based on my legal experience. So there's a few things you need to consider. Number one is, what type of loan is this? It's a very important question, because if it is a loan that involves or falls within the scope of credit lending activities, and in Australia that is governed by the ASIC Act, and we do have very strict credit laws here. So if you are involved in credit lending activities and you have a license to engage in such activities, then you can pursue such loan. However, if you don't, then there will be consequences for you and penalties. So you need to think about that, and it is most likely not going to succeed. The prospect of success in pursuing this will not be successful. So those are very important things. First is to know what type of loan it is. And number two is that if you're not engaging in credit loan activities, then you can pursue it. You can pursue it in court. But I would say before you go to court, you normally would have a letter of demand to be put to the other side, demanding them to make a payment, so then you don't have to pursue it in court and incur further costs and so forth. So you need to give them notice first that you're actually pursuing that amount from them. And then you can make a claim in the courts. So there's all these other factors that you need to think about. But definitely you can pursue it, and it really is a matter of what type of loan it is. And you've also got to think about the amount of that loan, because if it's not a significant amount, you really need to think about the legal costs of pursuing such claim, because that could go beyond the amount that you're trying to claim. The legal cost and fees and so forth of applications and so forth can outweigh the amount pursued, and then you're spending more money just to pursue the claim. So those are the things you need to consider. There's an ASIC Act, and then we have credit laws like the National Consumer Credit Protection Act 2009. And so credit activities is things like what the banks do when they lend. And before they can lend, they have to have pre-contractual documents. They give you an offer. Normally it falls into what we call a letter of offer, stating what product it is, what's the principal sum, the amounts, that late fees, interest, and so forth, how that's applied. And those things are extremely important, and they must comply with that before they allow you to have a certain amount of money to be loaned. They have to go through all that assessment as well. And we have these very strict laws in place to protect society, to protect consumers, because the financial institution such as the bank has very big bargaining powers, and it's easy to take advantage of those who are vulnerable, who want to have a loan but may likely not even be able to meet those loans or be able to pay it. And so that's why there is an assessment from the outset, and that they are loaned an amount that is respective to their income or whatever the assessment requirements are. And it ensures that that person is protected from being so indebted that they're not able to progress in their life. And so this now falls within that kind of anti-slavery concept, where in Australia we have anti-slavery laws. We're coming into a world where we have financial slavery. And so these are the things that I think our legislation, credit laws, and the ASIC Act tries to prevent from happening here in Australia. So those are the important things. And one of the cases that comes to mind was a matter that was brought to my attention where there was a private loan, and the parties actually engaged lawyers where they drafted a contract and they signed it, and their respective lawyers actually witnessed it. Now, when this matter was brought to my attention, and upon review of what type of loan it was, it came to our attention that it falls within the ASIC Act of what would be considered a credit lending activity. And we discovered that they did not have, upon doing our due diligence and research, that the other party did not have the license to engage in such activity. We clearly then put the other side, who had counsel and solicitors, on notice that you don't have a credit license, and so you had no right to even engage in such activity nor enter into any contract with anyone. So we have not heard from the other side, and the reason being is because they have breached the ASIC Act from the outset. And if they were to pursue this matter, then they would have consequences that they will face far greater than trying to pursue a claim where their prospect of success was effectively slim. There's no success there because they breached the law. If you breach the law, can't claim any amount. There would be penalties that apply, and so they did not pursue this matter. And that's just one of the examples. Another example I have is a deceased estate where a bank themselves have tried to pursue a credit card, and they just say, look, the estate has a credit card debt. What do you think I did? Ask them for the contract, because that is how you verify that they have a right to make a claim. We have these laws in place, and they could not provide such documents, and so they closed the account. Estate will not pay for an amount that is being pursued that is not verified and is not justly supported by a legal right to make a claim. And in this instance, that's the reason why when you draft a will, it states just debts, J-U-S-T, debts. And it is for the executor and the lawyers to verify each debt. And if the bank cannot support their claim, then it cannot pursue that debt because they don't have a legal right to. These laws are in place to protect consumers in our society. And any breach attracts penalties, and there are consequences. And that is pretty much what you need to consider.